diyorum bakın diyorum bir WhatsApp grubumuz var.
Yayında mıyız? Herkese merhabalar, günaydınlar. Bu cumartesi gününde vakit ayırıp buraya kadar geldiniz, panelimize katıldınız. Öncelikle sizlere teşekkür ediyorum. Ben Avukat Hasan Hüseyin Alparslan, Tüketici Hakları Kurulu Başkanıyım. Bu dönem bir yıllık bir süreç için seçildik. Tüketici Hakları Kurulu olarak çok güzel çalışmalara imza atmaya çalışıyoruz. Yaklaşık 2,5-3 aylık süreçte 7 toplantı, 6 ders yaptık. Kurul içi çalışmalarımıza aktif bir şekilde devam ediyoruz. Katılmak isteyen meslektaşlarımızı kuruldaki çalışmalara her zaman bekliyoruz. Baromuza verilecek bir dilekçeyle kurul üyesi olup programlara katılmanızda hiçbir engel yok. Hatta sizin katkılarınızla kurul daha çok büyüyecek, çalışmalarda güçlenecektir. Bugün de meslektaşlarımızla biraz da mesleğimizde eksik olduğunu düşündüğümüz bir konuda hem farkındalık yaratmak hem de bir başlangıç yapmak için bir program hazırladık. Şebnem Hocam sağ olsun bize çok büyük bir destek verdi bu programın hazırlanmasında. Hem program içeriğinin hazırlanmasında hem de buraya gelerek cumartesi günü vakit ayırarak bilgilerini ve bir takım deneyimlerini bizlerle paylaşmak açısından bize katkılarını sağlamak için buraya geldi. Ben hepinizin huzurunda öncelikle kendisine çok teşekkür ediyorum. Bugün biz bir söyleşi havasında tüketici hukuku ile ilgili bir sohbet, İngilizce terminolojiye ilişkin bir giriş, sizlerin katılımıyla, sorularıyla, değerlendirmeleriyle bir söyleşi havasında bugünü tamamlamak istiyoruz. Bugün bir başlangıç olsun. Meslektaşlarımızın hukuk İngilizce konusuna bakış açılarını, farkındalıklarını artırabilirsek bundan sonraki süreçte çok daha güzel, çok daha geniş katılımlı, çok daha büyük etkinliklere ev sahipliği yapmak istiyoruz. Ben sözü çok uzatmak istemiyorum ve Şebnem Hocama veriyorum. O da fikirlerini, görüşlerini paylaşsın. Sonrasında yavaş yavaş programa başlayalım. Buyurun hocam.
Çok teşekkür ediyorum. Herkese günaydın öncelikle. Burada çok yoğun bir katılımımız yok ama umarım YouTube kanalından seyrediyorsunuzdur. Buraya gelen arkadaşlarımızın hepsine de ayrı ayrı çok teşekkür ediyorum. İyi ki geldiniz, iyi ki buradasınız. Aslında bu yapacağımız bir ilk olacak. Tüketici Hakları Kurulu ve kurul başkanımız bu öneriyle bana geldiğinde çok hoşuma gitti. Çünkü tüketici hukuku aslında daha ziyade Anglo-Sakson kökenli gelişen ve özellikle de bizim ülkemiz bünyesinde tamamen Avrupa Birliği çerçevesinde ve hatta Avrupa Birliği ile uyumlaştırılarak gelişen alanlardan bir tanesi. Bunun sebeplerini de yani bugün ve bundan sonra yapacağımız toplantılarda biraz anlatmaya çalışacağım neden bu noktaya geldiğimizi. Ve bunu o yüzden dedik ki aslında tüketici hukukunu iyi anlayabilmek için Avrupa Birliği'ndeki tüketici hukukunu bilmemiz, Avrupa Birliği'nin bu alandaki direktiflerini bilmemiz, farklı ülke uygulamalarını bilmemiz lazım ki kendi hukukumuzu ve kendi kanunumuzu da daha iyi değerlendirebilelim, daha iyi anlayabilelim. Nasıl işte bir borçlar kanunu, medeni kanunu anlarken İsviçre'ye dönüp bakıyorsak aslında burada da Avrupa Birliği'ne dönüp bakmamız gerekiyor. İşte bu noktada da uzun zamandan beri de Hasan Hüseyin Bey ile konuştuğumuz bir şeydi bu aslında. İngilizcenin geliştirilmesi, avukatlar arasında İngilizce kullanımının geliştirilmesi. Dedik bu ikisini birleştirelim. Madem tüketici hukuku alanında da Avrupa Birliği önemli, Avrupa Birliği direktifleri, oradaki uygulamalar, farklı uygulama örnekleri önemli. Öyleyse bunu biraz İngilizce yapalım. Hem İngilizce kullanımımız, konuşmamız gelişiyor olsun, hem de nereye nasıl bakacağımızı biliyor olalım diye düşündük. Bir taraftan da onu da hatırlatayım bütün arkadaşlarımıza, hem burada bulunan arkadaşlarımıza hem de bizi kanaldan izleyen arkadaşlarımıza. Baromuz nezdinde ilk defa bir İngilizce konuşma kulübü de kurulacak. Buna da lütfen dikkatinizi çekmek istiyorum. Sanırım başvurular 14 Şubat'a kadar mı alınacak Hasan Bey?
Evet hocam. 14 Şubat'a kadar başvurular alınır.
Şubat'a kadar başvurular.
Sonrasında da bir çalışmalar başlar.
Çalışmalar başlayacak. Hani ben bugüne kadar hiçbir kulüpte bilfiil yer almamıştım. Bu kulüpte bilfiil yer almak istiyorum. Ben de başvurayım bari. Ya da şimdiden almış olun benim başvurumu da.
Çok seviniriz hocam. Hemen bu noktada çok küçük bir parantez. Baronet üzerinden başvurular alınıyor. Ankara Barosu Baronet sistemi üzerinden.
Çok güzel.
14 Şubat'a kadar sistemden başvurular alınacak. Sonrasındaki SMS'lerde üyeler üzerinden gideceği için Baronet sayfamızı kullanarak üye olmak önemli. Bunu da buradan hatırlatmış olalım.
Tamam, süper. Bunu da hatırlatmış olduk. O konuşma kulübünde de hatta biraz önce aramızda da sohbet ettik. Çok farklı konularda. Yani sadece tüketici hukuku değil, çok farklı konularda içinde ticaret hukukunun farklı konuları olabilir, sözleşmeler hukukunun farklı konuları olabilir, aile hukukunun farklı konuları olabilir. Sırf deneyim paylaşma, tecrübe paylaşma, anı anlatma, buna ilişkin konular olabilir. Yani burada amacımız amacımız aramızda sohbet etmek suretiyle aslında İngilizcemizi biraz geliştirmek, İngilizcemizi işlerlik kazandırmak tabiri caizse ve ileride karşılaşabileceğimiz yabancı müvekkillerimizle çok rahat bir şekilde sohbet edebilecek bir ortam yaratmak. Bir taraftan sadece hukuki anlamda değil, onlarla sohbet edebilecek de, onların dertlerini, isteklerini, bizden beklentilerini daha iyi anlayabilecek de bir kullanıma sahip olabilmek dili. Yani aslında bu ikisi birbirine paralel gidecek programlar diyebiliriz. Burada biz ne yapmaya çalışacağız? Ondan kısaca bahsetmek istiyorum sizlere. Tüketici hukuku tabii ki buradaki odak noktamız bizim. Ve ayda bir yapalım diye planladık Hasan Bey'le. Haziran ayına kadar, Haziran yapar mıyız yapmaz mıyız talebe göre, ama mutlaka bundan sonra Mart, Nisan, Mayıs'ta birer toplantı yapmayı planladık. Bu toplantılarda da bir toplantı öncesinden belli bir konu belirleyip bu konu üzerinde sizlerin de katkılarıyla bir sunum ve tartışma yapalım. Yani bunu birazcık çalıştay, birazcık söyleşi, birazcık panel, hani üçünün ortak bileşeni bir çalışmaya dönüştürelim istedik. Ve bundan sonraki konumuz olarak da gelecek ayın, Mart ayının konusu olarak da mesafeli sözleşmeler, distance sale contracts. Bunu belirledik. Distance sales, mesafeli sözleşmeler tabii çok çok önemli, hepimizin bildiği gibi ve özellikle de son yılların, son günlerin, hele bu pandemiden sonranın moda konusu. Neden? Çünkü mesafeli sözleşmeler çok fazla arttı. Özellikle de internet üzerinden kurulan sözleşmeler. O yüzden biz bundan sonraki ayın konusunu distance sales olarak belirledik. Bu konuda sizlerden ricamız, şimdi Hasan Bey bir tarih verecek size. Bu tarihe kadar 5 dakika, 10 dakika, 15 dakika. Çok değil. Maksimum 15 dakika, 5 ila 15 dakika arası. İngilizce sunum yapmak isteyen arkadaşlarımızın sunum yapmasını istiyoruz. Hangi konuda? Kendi belirleyeceğiniz bir konuda. Nasıl bir konu belirleyebiliriz? Bir ülkeyi alabiliriz ele. Özellikle Avrupa Birliği üyesi ülkelerden biri olursa daha güzel. Ama farklı bir ülkeyi de alıp hani bir karşılaştırma yapabiliriz. Bu ülkedeki distance sales, mesafeli sözleşmeler alanındaki düzenlemeler neler? Neyi düzenlemişler, nasıl düzenlemişler? Özellikle internet üzerinden yapılan satışlarda neler ön plana geçiyor? Nasıl bir koruma sağlanıyor tüketiciye? Belki işte bu koruma sonucunda bir uyuşmazlık olursa bu uyuşmazlık nasıl çözülüyor? Bunları içeren 5 ila 15 dakika arasında çok uzun olmayan küçük, net bir sunum. En az 3-4 arkadaşımız da bu şekilde farklı ülkeler seçerse, mesela bir arkadaşımız Avrupa Birliği'ndeki bu konudaki farklı direktifleri de alabilir. İşte distance sales'a ilişkin direktif var, Avrupa Birliği'nde elektronik commerce'e ilişkin direktif var, tamamen internet üzerinden satışlara ilişkin direktif var, uyuşmazlık çözümlerine ilişkin direktif var. Bunlardan birini de seçebilirsiniz. Hani ben ne yapmaya çalışacağım? Biz Hasan Bey'le belki işte Türk mevzuatını biraz anlatırız. Bizim durumumuzu İngilizce olarak anlatırız. Ama sizler de farklı ülkeleri ve Avrupa Birliği'nin direktiflerinden işte istediğinizi seçerek en az 3-4 arkadaşımız böyle bir seçim yaparsa hani burada 1-1,5 saatlik keyifli bir tartışmalı bir ortam yaratmış oluruz. Hem farklı ülkeleri görmüş oluruz, hem farklı bir ülke hukukunu nasıl araştırırız bunu da birazcık öğrenmiş oluruz. Hepimiz için çok faydalı olur diye düşünüyorum. Hasan Bey, hangi güne kadar arkadaşlarımız nereye başvuru yapsınlar bununla ilgili?
Hocam ben takvime baktım, 18 Şubat diyelim, 2 hafta sonra
Süper,
Cuma günü.
süper.
Çünkü Mart ayının programını hazırlamak için de bize
Tabii.
bir vakit kalmış olur.
Tabii.
Mart ayının hangi tarihinde yapacağımız şu an belli değil. Hem ABM'in müsaitlik durumuna hem hocamızın programına göre tekrar bakıp bir program tarihi belirleriz ama 18 Şubat'a kadar isterseniz doğrudan benimle iletişime geçebilirsiniz. Ben programın koordinasyonunu yürütüyorum çünkü şu an için. İsterseniz Tüketici Hakları Kurulu üzerinden de bu başvurularınızı yapabilirsiniz. Ama doğrudan benimle iletişime geçerseniz daha hızlı bir şekilde aksiyon alabiliriz. Yani burada sunum yapmanız için illa Tüketici Hakları Kurulu üyesi olmanız da şart değil. Ben hocam söylemişken şöyle çok kısa bir anekdot paylaşayım. Hayatımda ilk defa İngilizce sunum yaptığımda nefesim kesilmişti. Yani nefes almakta güçlük çektim. Bir hazirum var karşınızda. Bir kelime hatası yapar mıyım, yapmaz mıyım onu düşünüyorsunuz. Hukuk anlatıyorsunuz. Bir terminolojiden bahsediyorsunuz. Bu gerçekten insanı ilk başlarda çok geren bir şey. Bunu çok iyi anlıyorum ama ya her şeyin bir başlangıcı var. Bir yerden buna başlamak lazım. Burada biz bizeyiz. Baromuz içerisinde, kendi meslektaşlarımızla sohbet havasında bir hata yaparsak da bizim hatamız. Bunu düzeltmek de yine bizim borcumuz. Burada olabilecek her türlü olumsuzlukta, her türlü hatada bizim size destek olacağımızı unutmayın. Hocam da söyledi zaten 5 dakika, 10 dakika. Kendinizi burada ne kadar ifade etmek isterseniz katılımlarınız bizim için çok kıymetli. Açıkçası bu kuruldan ziyade sizin için daha kıymetlidir diye düşünüyorum. Çünkü siz burada ilk sunum yaptığınız zaman inanın ikincisini yapmak için can atacaksınız diye tahmin ediyorum. Bilmiyorum hocam da benimle aynı fikirde midir? Bir de bu hukuk incesi konuşma kulübündeki bir amacımız da şu. Meslekte bir noktaya gelmiş büyük meslek üstadlarımızla genç meslektaşlarımızın iletişimini de sağlamak. Çünkü onlardan öğreneceğimiz çok şey var. Ben buna avukatlıkta çok önem veriyorum. Bir usta-çırak ilişkisi resmi olarak yoktur avukatlıkta, kıdem yoktur ama ben kıymetli üstadlarımızdan çok şey öğrendim. Onlarla aynı ortamda bulunmak da bana çok şey kattı. Bu kulüp umarım biraz ona da vesile olur. Sözü de çok uzatmayayım. 18 Şubat'a kadar burada sunum yapmak isteyen meslektaşlarımız tabii belirlemiş oldukları konu başlıklarıyla birlikte benimle iletişime geçerlerse buradaki programa onların katkılarını da alalım. Bizim burada söylediklerimizin dışında tüketici hukukunu ilgilendirdiğini düşündükleri başka bir konu olursa yani yine çekinmesinler. Bize konu önerileri gelsinler.
Bir sonraki ayda onu değerlendiririz.
Bir sonraki
Tabii.
programlarda da mutlaka onları değerlendiririz. Mesafeli satışlar çok çok önemli bir konu artık. Bugün Çin'den, Japonya'dan, Amerika'dan, İngiltere'den bir tıkla sipariş verebiliyorsunuz. O kadar kolay. Kredi kartlarının da kullanımı çok arttığı için. O yüzden bir sonraki sunum konusunun ne olmasının daha uygun olacağını düşündük. Ben sözü çok uzatmayayım ve let's continue in English.
Let's continue in English, okay.
Yes. Today our subject is consumer law and our guest is Professor Şebnem Akpek Öcal. She is going to introduce us the consumer law in European Union and some of the countries in the world. I want to give the word to my professor. Thank you very much for your attribution.
Thank you very much. Actually, what I would like to do is I would like to start by telling a very nice memory for me because Hasan Bey, you said that it's really difficult to start speaking in English or in another language if you're not a native of this language. And especially to lecture or to give a conference in that language, it's not very easy. I think I was very lucky. Why? Because I had to experience that without any preparations. So I immediately got used to it. I started as a research assistant ages ago. Ages ago, yes, unfortunately. And my professor was Professor Lale Sirmen. And maybe you know her. She's a wonderful person, but she is very disciplined. And I started as a research assistant. I started actually, this is my 32nd year in the profession. I started on the 2nd of February, 1990. So it's a very long period of time. And after a couple of weeks, I started. My professor was also giving lectures in Middle East Technical University, and I had no education in legal English, and I only completed the law faculty and started as a research assistant, and I also started my master's degree in Turkey. Then I went to England and had my master's degree there, but I started my master's degree in Turkey. And after I was appointed, I think it was 3 weeks after my appointment, my professor phoned me. We did not have any, of course, cell phones or any other thing in those days. My professor phoned me late at night, and she said that tomorrow morning I have a lecture at Middle East Technical University. It is the second week of the lectures, and I'm lecturing law of obligations, and this is the topic, and you would be going there to lecture. And she said, the lectures are in English. And I only had my English from my high school, and I never used it during my legal education and lecturing in law of obligations. And of course, it's not something very difficult. Yes, it's very challenging. What would be happening?
I think it is not possible.
It's not possible. She's a wonderful person anyway.
Yes.
So, and what happened is that I went to Middle East Technical University and I lectured. So this was the first time that I lectured in English. But it was quite good actually, because when you have to do something, you do it. That's what I learned in life. if you have to do something, you simply do it. You have to do it. So, and then I had no difficulty. Because what I learned was that if I start thinking in Turkish, it would be impossible for me to speak in English. So I had to think in English, I had to respond in English, and this was just the beginning of me to lecture in the language and to study in the language. Then I went to England and I had my master's degree there. And of course, when you have your master's degree there, you have to understand everything, you have to take the notes. And it's not easy, it's always very challenging. You have to study. What happened was that the first days of the lectures in England, of course, it was very difficult for me, especially to take notes, because in the law faculty in Ankara, I was a hardworking student and I was able to take notes, and I was always preparing myself from my notes together with the books, and I thought that in England I had to do the same thing in the master's. But following the lecture, taking the notes in English, trying to understand the lectures, one of my lecturers was from Australia, one of my lecturers was from Scotland, and you can imagine their pronunciations and everything. So everything was very challenging. And the first weeks, it was really very difficult.
And the legal system is different.
And the
from
legal
Turkey.
system
This
is
the
difficult.
common law
Of course,
system, and
it's completely difficult.
you have civil law
Yes,
system. It's very hard
yes.
to understand
It's
sometimes.
very hard to
Because
understand.
the legal terminology is very different from Turkey.
Yes, that's what I would like to stress, actually. The concepts are even very different from each other, most of the concepts. But what happened in a couple of months' time is that I was able to take notes, and even my friends, my English native friends, were also asking my notes from me. So you have to do that. You have to study. If you want to improve yourself in a language, the only thing you have to do is just to use this language. You may not be able to use it orally, of course, but at least you should read. So that's what I would like to advise you. Please read a lot. If you read in English whatever you want, it can be a novel, it can be a romantic novel, it can be a fiction, it can be whatever you like. It shouldn't be, of course, all the time law. It's not very enjoyable most of the time to read legal texts, but just read. You can read some periodicals, you can read some magazines, you can read some books, whatever you like. But this is the only way to keep your language and to improve your language. Also, if you try to talk at least among yourselves in English, that's why this English law club will be something really very, I think, important for most of the lawyers in Ankara. If you just push yourself to speak in English, to chat in English, I think it would be wonderful. Would you like to add something at this moment? Please use the microphone.
Yes.
First, please introduce yourself.
Do you hear me?
Yes.
Okay. My name is Erkan Kaynarca. I was about to say something about the topic. You really need it. If you need it, you can do it. You know what they say, necessity is the mother of invention. You can invent so many things if you really need it. I have graduated from Ankara University Law School. Here in Turkey we say Faculty of Law, but if you go to a common law country, they say law school, medical school. After law school, I tried to work as a litigation lawyer for a while, but I didn't love the practice of law as a litigation lawyer. So I started to write contracts in English in some banks and other foreign companies. I like it very much, but to be proficient, fluent, you have to keep reading. Reading is really important. It's a science fiction, love novel, whatever it is. And for your listening abilities, if you watch TV, especially news from BBC and CNN, it can be helpful. But here at this point, maybe at the start of this kind of meetings, this is our first encounter with so many lawyers, I hope so. from all over Turkey, let's say. I hope other bar members of the bar associations hear about these meetings and follow us. I'm an English freak, really. I try to do everything in English if I can. But I'm really a strong supporter of the belief that there is no legal English, because I say when we start law school here in Turkey, we didn't need to learn legal Turkish. Just for a week or for a month, for a few months, we look up into a dictionary for a few words, and then we learn. For example, so many years ago, there were so many words, Arabic and other words. That's why we couldn't understand them. For example, ma'ada means başka, other. We were trying to understand that kind of words. But today, it's really easy. That's why I say that there is no legal Turkish, legal English, just some specialized words. If you start to read, for example, you can give me a book about astrology. I haven't got the faintest idea about astrology, but if you give me a few weeks and a book, I can pass my astrology 101 examination in a few weeks, because I can try to understand after, what I would like to say is, after 25 or 30 pages, every book repeats the same words, okay? You got used to that terminology in the very first pages of that book. Please do not be afraid of this. You can learn that jargon, and you can understand that subject. And we are very accustomed to lots of words here in legal terminology, because most of them coming from Latin. Okay, don't worry. Of course, we are here if my esteemed professor and Hasan Hüseyin Bey let me contribute to this kind of legal talks. I would like to give some contribution, and I would like to share, let's say share, because I cannot say teach here. We can share our experiences, because I'm trying to write contracts in English, preparing some documents for international arbitration. So I would like to share all my experiences together with you. Most of the time, before starting a lecture, we were talking about secret recipes. People would like to learn very quick ways of learning this language, and especially legal English. There is no secret recipe. The recipe is hard work. The recipe is repetition all the time. The recipe includes working every day. Whether it is 5 minutes or 15 minutes, it doesn't matter, but every day, if you try to learn this language, you can do it. We were joking. You're going to crack 3 eggs and add some black pepper and other exotic herbs. Then rub that mixture over your eyes for your improving your reading, something like that. But joking apart, hard work is the key element. And thank you very much, first of all, our Professor Şebnem Akipek Öcal and Hasan Hüseyin Bey. It's really important to help all of us to have some time to practice our English. If our young friends say that you can help us, we will try to do our best. Please come here physically or follow us online. And if you give your backing, we will be here, and I will try to contribute from time to time like this. Thank you very much.
Thank you very much for your contribution. Actually, sharing the experience is the most important thing here. And what we need to know is English is not a very suitable language for our law system, for the continental law system. This is one of the most important things that you need to realize in using English language, because some of the concepts we have, they don't have in English law or American law or in general the Anglo-Saxon or the Anglo-American law system. They don't have these concepts. And some concepts they have, we don't have these concepts. Therefore, when we are using legal English, especially as my dear friend has explained to you, if we are drafting a contract, especially if in this contract the Turkish law will be the applicable law, we have to be very careful. Because what we do most of the time, or what kind of a tendency we have is, internet is a wonderful, wide range of different contracts. You can find everything in internet. And what we do most of the time, what I see in my experience is that some of my friends, lawyers, just take a couple of contracts and they prepare a nice mixture from these contracts. But these contracts are actually prepared in different law systems by using different laws. And it's very dangerous because some of the concepts they use, we don't have in our law. And some of the concepts they try to regulate, actually we have some compulsory provisions in these areas, and we cannot regulate them like that. So please, my first advice today, I will try to give you in each one of our series one advice. And today's advice is, please never copy anything. This is a very important advice because you have to be very careful in using the language, in using the concepts. Please don't trust yourself. Don't trust Google translations. Don't trust different contracts that are prepared previously that you can find in internet. So therefore, first of all, trust yourself. If you have any questions in your mind, please ask them to a more experienced person. This is something very important in using the legal English because sometimes you may harm your client by yourself more by preparing a contract that includes some provisions against the compulsory provisions of law, or that includes some provisions that are not covered in Turkish law, especially about the types of damage, for example. The types of damage are very different. Therefore, you have to be very careful in that sense. So this was today's advice. And now, let's try to
Maybe
move
I can
to
add a
yes,
small
please.
point.
Of course.
Consumer law is easier to
Yes.
teach in English because, as you said, we have an act about consumer law, but it comes from the European Union mostly, and
That's
we
correct.
have some translation mistakes also have in our
Yes,
act.
wonderful.
So it
The
is
law on consumer protection
Yes.
has some translation mistakes because some provisions of the law are directly translated from some of the European Union directives.
yes.
And that's really a very important point.
Yes, but it's easy for us to talk about consumer
Yes.
law in English,
Yes.
even if we are a Turkish lawyers or even if we practice in Turkish law system. And now we can talk about consumer
Yes,
laws.
that's
Who are
what-
consumers?
Yes.
What is consumer transactions?
Yes, actually, I will not be starting with who are the consumers, but I will be starting with the development of the consumer protection law. You know that we have a tendency when we talk about something different, a new concept or something, we try to go back ages ago and try to find some hints. Especially we use the Hammurabi laws, you know. And if we go back to Hammurabi laws, believe me, we have nothing about consumers. So we are very lucky. Then what do? We go to the Roman law period and we try to find some traces there. We're again very lucky, we don't have anything in Roman law. So we can say that actually consumer protection law is a fairly new field of law. It's a newly developing, a still developing field of law. We can say that. Of course, when we go back in the legal history, we can say the word consumer was not used. The words consumer protection were not used. But of course, we had some indirect ways of protection. It started especially in the Middle Ages, mostly we can say that. We had some indirect ways of protection, especially some indirect ways that are used among the tradespersons. Why? Because the tradespersons were bringing some ethical codes among themselves to codify, or in a way to regulate their relations among themselves. But when they brought some ethical codes, of course, these ethical codes helped the consumers as well, not directly, but indirectly. One of the most important examples of that can be seen in Ottoman Empire. Actually, these examples are also given in all the lectures worldwide who talk about consumer protection. Because the Ottoman Empire especially had, starting with the 13th, 14th centuries, a very important way to regulate the tradesman. And this was ahi. Ahi teşkilatı. I would be saying that in Turkish, of course. So this is the first indirect way to protect the consumers. And then, of course, in the world, it started to develop in different ways, again indirectly. The first direct way to protect the consumers can be named in the end of the 1900s, 1800s and beginning of 1900s, a new regulation that was prepared in the United States. Actually, the first thing to prepare this regulation was the start of the sales of Singer sewing machines. I hope that you heard about the Singer sewing machines. The Singer sewing machines was a really new thing for all the persons in the United States, because up to that sewing machine, everybody was sewing by hand. So it was something very difficult. And when the sewing machine was invented, everybody wanted to buy this machine. But of course, this machine was not a mass production. It was also produced by hand. Therefore, it was produced not in hundreds and hundreds of amounts, but in 2, 3, 10 amounts. But most of the people wanted to buy it. And it was produced by hand, so it was very expensive. There was a high demand, but there was a low supply. It was very expensive. So what happened was that the first installment sales started. What's installment sales? You sell the machine, but you pay it in installments, in monthly installments most of the time. And the first installment sales has started by Singer sewing machines. And the result is, of course, some problems started. And the first very, very short piece of law was prepared to protect the consumers and to regulate the installment sales. Of course, the word consumer was not used. The word purchaser was used. It was not consumer, but this was the first piece of legislation that was prepared in the history of consumer protection. Then what happened again in the United States is, a couple of years later, the prices of the meat increased hugely. And the first boycott in the history among the purchasers started. Nobody bought meat in the United States for about a month. And what happened is that the prices were reduced, and again, a very important piece of legislation was prepared, the Meat Inspection Act. So it was something really important, actually. These are some important steps in the development of consumer law. But the huge step, the most important step, of course, I will not be just boring you with these kind of examples. There are many other examples. But the most important step was taken on 15th March, 1962. Have you ever heard about the importance of 15th March? I don't know. I hope we shall be doing something on 15th March.
I don't remember actually.
We have to do. It's the World Consumer Protection Day. And we
Yes,
always
but
do something in Ankara Bar.
Yes, but
So we
I
have
cannot
to do
remember
that.
the source of the
Yes,
day.
I will
remember the day,
explain.
of
Yeah,
course, I remember,
okay.
but
I will
I
explain
cannot
it.
remember the...
I will explain why is it important. the 15th March 1962 is a milestone in the development of consumer protection law. Why? On that date, John Kennedy, one of the presidents of the United States, has made an opening speech of the Congress in the United States. And the most important topic of the speech was consumers and consumer protection. Kennedy is the first person in the world who pronounced adds the word consumer and consumer protection, and who named the first 4 consumer rights in the history. So this opening speech is a very important opening speech, and because of that reason, in the beginning of 1980s, the United Nations declared 15th of March as the World Consumer Protection Day, as the World Consumers Day. So it's a very important date. I will try to read 2 sentences from Kennedy's speech. Consumers, by definition, include us all. They are the largest economic group in the economy, affecting and affected by almost every public and private economic decision. So these were Kennedy's words. And what he mentioned is there are 4 important consumer rights. He said, I will not be counting these rights because these rights have been developed in the future. But another important thing Kennedy has mentioned is that the state has a duty to protect consumers. We have to prepare legislations, we have to take precautions to protect the consumers, and the consumers should also organize among themselves to be heard better. If they are just one by one, it's difficult to hear the consumers, it's difficult to represent themselves. But if they organize, if they form associations, if they form other types of unions, then it would be easier to be heard by the consumers. That was what Kennedy has mentioned, actually. And this date, after this date, the consumer protection movement spread hugely among the world. It spread to Japan, to Australia, to Canada, to the many different European countries and many other countries in the world. And the consumerism movement has started after that. So this date is a very important date. Now, I would like to take a look at the European Union a bit. What happened in the European Union? You know that. European Union is the result, but its starting point dates back to 1951. It started with the coal union of the European countries, and it developed to nuclear energy union. Then it developed to European economic community, actually. It was not a union these days, it was a community, European economic community. And it dates back to 1957. It started with the Rome Convention of the European Economic Community. Then it turned into the European communities, then it turned into the European Union. So it's a long history. I will be always mentioning it as a European Union just to keep it short, but of course please know that in the history it had different stages. I will be mentioning as the European Union. When we take a look at the first convention that built the European Union, the Rome Convention in 1957, we can see that there was nothing, no trace of the consumers, nothing about the consumers. But after 1962, also in the European Union, a consumer understanding actually started. In 1962, actually, the first bureau to protect the consumers was built, the BEUC was built in the European Union, and they started to talk about the consumers with the effect of the Kennedy speech, actually. But this was not something very developed. These were the first efforts, actually, not something developed efforts. The first real effort in the European Union was in 1972, in Paris Summit. There was a Paris Summit, and in that summit, they said that we have to do something to protect the consumers in the union, and we need to have a policy to protect the consumers. So we have to develop this policy. What we have to do is we have to form a commission. This commission should prepare an action program, and we have to introduce this program as the first consumer protection program in European Union. And that was what they did, actually. They formed the commission. This commission worked hard, and as a result, in 1975, they established the first consumer protection program. And what they did is the European Union declared with this program 5 important consumer rights. These consumer rights are known as, I can say, the Constitution of the Consumers, or the first Declaration of Consumer Rights in the world. These 5 rights were developed by the United Nations 2 times, first as 8 rights and second as 10 rights. But when we take a look at these 10 rights that have been developed by the United Nations, we still can see that they have their roots from the European Union's 5 rights, actually. So we have to know these 5 rights very well. And when we take a look at our consumer protection law, the law on consumer protection, our law also depends on these 5 important rights. What were they, or what are they? We still use these rights. The right to protection of health and safety. The right to protection of health and safety. The second one is the right to protection of economic interests. The third one is the right to protection of the information and education, the right to be informed and to be educated. The fourth one is the right to redress, or we can say the right to damages. And the last one is the right to representation and to be organized. The right to representation and to be organized. So these are 5 important rights of the consumers. Right to health and safety, right to economic interests, right of economic interests, right of information and education, right of representation and organization, and right to redress or right to damages. So these 5 rights are the core elements of the whole European Union. And then what happened is that in the European Union, they started to publish different types of legislation. At this point, we have to take a look at the European Union's legislation. Actually, when we talk about the European Union, first of all, we have to mention that it's a supranational law. It's not an international law, but it's a supranational law. It's a supranational law for its member states. And in the European Union, they have 2 different types of legislation. The first legislation, they say, or the primary legislation, and they have the secondary type of legislation. The primary legislation directly affects the member states and directly becomes binding and effective for the member states. What are these? These are the conventions of the European Union, starting with the Rome Convention. They have many different conventions. The Maastricht Convention, the Lisbon Convention, the Amsterdam Convention, many different conventions. This is the primary legislation. For the primary legislation, the member states do not have to do anything. Just being a member state, it means that this primary legislation is directly binding for all the member states and becomes effective in those member states. But actually, how the European Union regulates the law among itself and among its member states is with the secondary type of legislation, or the secondary legislation. And the secondary legislation includes regulations and directives. The European Council issues regulations and the European Commission issues directives. And what happens is that with these regulations and directives, they bring some important minimum standards for all the member states. And the member states should adopt these standards in that area of law according to that directive or regulation. This is named as harmonization. Maybe you heard about the term harmonization in the European Union. It means that the member state countries should harmonize their law systems in accordance with the regulations and the directives. And to do that, of course, they can follow different ways. The first way they can follow is if they have already these provisions in the regulations or directive, they don't have to do anything. They may already have that in their own legislation, so it's okay. They may partially have them in their legislation, so what they have to do is they have to add the missing points. If they don't have this legislation in their own system, they have to either enact a new law or add some provisions to their existing laws to introduce these provisions to their law systems. That's how they harmonize their law. And in this harmonization, the important thing the European Union adopts is that you have to be in the same line with the European Union directives and regulations. In other words, you have to harmonize your law system just in accordance with these legislations that is put forward by the European Union. But in consumer law, they have a different approach. And this is the only approach they have in consumer law. It's a very different approach than in every other area of law. And they say that in consumer law, we bring the minimum standards by our regulations and directives. Each member state is free to adopt a higher standard. So only consumer law enables the member states to change their law systems differently from the European Union. The European Union is the minimum standard. They have to adopt that. But if they want, they can bring more provisions to protect the consumers in a higher level. So this is something very different in the policy of the European Union, and the consumer protection area is the only area that they enable the states to bring higher protection levels in the consumer protection. Now, with their new programs starting in 2020, which will be going forward to 2025, this is what they're discussing, because the European Union countries have some different legislation among themselves, because some of them have higher protections and some of them only have the minimum standards. And now, since they are a single market, and since especially our next topic, the distance sales, especially the internet sales, is increasing hugely, they started to discuss that. Are we doing something correct? What do we have to do, especially with the increasing technology, the usage of technology, the usage of internet, the usage of all kinds of electronic commerce tools? Sometimes it's very difficult because in one country the consumers may have more rights, in another country the rights are less, and it depends on the protection from which country you are buying something or you are traveling to that country, and so on and so forth. So they started to discuss that. But this was something very important in those days, and this showed actually that the countries may bring some higher levels of protection. This showed the importance given in the consumer protection area in the European Union. Now, I would like to just tell you some 10 basic principles of consumer protection in the European Union. These are some daily principles of consumer protection. This is something quite nice. I like that very much. What does it say? Buy what you want from where you want. Buy what you want from where you want. If it doesn't work, send it back. If it doesn't work, if it is defective, if you're not happy with it, send it back. High safety standards for food and other consumer goods should be brought, and you should look for them. High safety standards for food and consumer goods. Know what you're eating. This is something also nice. Contracts should be fair to consumers. Contracts should be fair to consumers. Sometimes consumers can change their minds and we have to show respect. Sometimes consumers change their minds and we have to show respect. Making it easier to compare prices and compare the prices. Consumers should not be misled. The misleading advertisements and such things. Consumers should not be misled. Protection while you're on holiday. You should be protected on holiday as well. Just think about the package tours and travels and things like that. Effective redress for cross-border disputes. Effective redress for cross-border disputes because we are having cross-border disputes. We don't have any borders actually. So we have the national laws still, but these national laws should be protective. And you should choose the countries that are more protective. This is what actually they are trying to advise the consumers. And of course, I have many more things to explain, but I don't want to bore you. So should we stop here? What do you say?
Whatever you want, we can do, my professor.
Maybe we can
I
take
can add
some-
something.
Of course,
I can add
please.
something. Why did we start with the European Union system? Because Turkish consumer law system mostly affected from European Union's consumer law regulations. That is why we started with the European Union legislation. Our acts, our other regulations in Turkey, whatever we have in force up to date, are mostly translated from European Union's legislation.
Why? Do you know that?
Because Turkey is the official candidate of the European Union, and
Not only.
maybe you can add one more point.
This is one of the most important reasons.
Yes.
But we have another very important reason. At this moment, let me talk about the Turkish law a bit. In Turkey, the first time we mentioned the word consumer and consumer protection is the year 1982. With the 1982 Constitution, the Constitution's Article 172. So it was the first time in our country that we used directly consumer and consumer protection. Article 172, if you have a chance to read it, it's a very short article. What it brings to us is that the state has to protect the consumers, the state has to take the precautions to protect the consumers, and the state should, in a way, push the consumers to form their organizations to protect themselves better. That's what's regulated in 172 article of the Constitution. After that, after 1982, after we brought this article to our system, there were some attempts to bring some new legislations regarding the consumers. Of course, we had many different types of legislations. We had the Code of Obligations, we had the Commercial Code, we had several codes regarding the food safety, drugs, and such things, of course. But these were indirectly regulating the consumers. There were some attempts to regulate, to bring certain legislation to that area, but they all failed. But what happened in the beginning of 1990s, 1990, 1991? You know, Turkey has a long-lasting relation with the European Union. Actually, Turkey was one of the very first countries that emerged the European Union in the very beginning. It was 1963 with the Ankara Agreement. Ankara Agreement is a very important
It's a long adventure for Turkey.
It's a very long adventure. What I mostly say is that it's like engagement.
Yes.
You know, some engagements are very short and we get married very quickly. Some engagements are very long. And if the engagement is getting longer and longer, what happens is that sometimes you are very in love, sometimes you are far apart from each other. And the relations with Turkey and European Union, I always say that it's a very long-lasting engagement. Sometimes we are really very close to each other, sometimes we are hating each other. So in the beginning of 1990s, we were very close to each other. Why? Because Turkey wanted to be a part of the customs union. And the European Union also wanted Turkey to be a part of the customs union because Turkey had relations with nearly all member states, buying certain things and selling certain things. Therefore, customs union was very important for both sides, actually. And they said that for entering the customs union, Turkey has to do certain things, especially in 3 areas. Turkey has to harmonize. Be careful with the word I use. It's like the member states. You have to harmonize your legislation with the European Union legislation in 3 areas. What were these areas? One of them was the copyright protections and these kind of trademarks and these kind of protections. In that area, we were in a way better compared to the other 2. The other 2 areas were competition law and consumer protection law. They said that you have to harmonize your legal system with the European Union legal system like a member country because you will be part of the customs union. Therefore, you should have the same competition policy. You should have the same consumer protection policy with the other member states. So what happened was that Turkey decided to prepare a detailed legislation. But this legislation, this is the law on consumer protection, actually, the first law on consumer protection, should include the areas that were regulated with the directives and regulations of the European Union that are missing in our system. For example, consumer credit. Consumer credit is not regulated in our system. Distance sales, it's not directly regulated in our system. So these should be included in the legislation. Some areas are regulated in our system, but not in real harmonization with EU. So we have to regulate them as well, like the defective goods. So we have to regulate them as well. But some areas are regulated in our existing legislation, so we don't have to regulate them. For example, about food safety. For example, about drug usage. These are already regulated in our system, so we don't have to regulate them. We have some provisions, for example, in our Code of Obligations. We have some provisions in Commercial Code. We don't have to regulate them again. So what we have to regulate in our new legislation is the areas that are missing and the areas that are not in full harmony. So actually, the law on consumer protection in 1995 was prepared with this approach. And I think I was lucky or unlucky. Well, I don't know now. I always say that lucky, but I have some doubts sometimes. Anyway, they formed in the state planning organization a commission. There was a commission to prepare the law. But they formed another commission in the state planning organization in 1993, actually. And the duty of this commission was to, in a way, collect all the directives and regulations of the existing ones of the European Union and to compare them with our existing legislation and to prepare a report which is missing, which is not missing. What should we regulate, what we don't have to regulate, so that this report will be helping the commission that prepared the law. And I was the reporter of this commission.
I think it's a luck.
I'm not very sure. In those days, I was very young, of course, and I had no idea that a reporter, what I was thinking when I was appointed as a reporter of this commission was that there were 70 or 75 persons in that commission from different ministries, from different faculties, different places, and they were all under a duty to prepare their own reports regarding their own areas. And what I was thinking is that everybody would be bringing their reports and I would be collecting them and I will prepare the last report. But of course, only among these 75 persons, about 10 or 11 of them brought some reports, and the others always talked and never brought anything. So the result was I had to prepare. So I did not know that at that time. So actually, the law is prepared like that. It is an exact harmonization of the European Union. Of course, there were some missing points. Some of these missing points were filled in 2003 in a very huge amendment of the law. And unfortunately, we shall be talking about that in other sessions, I guess. Unfortunately, our Court of Appeals had a very wrong understanding of the law and had a very wrong application of the law. And what happened is that in the year 2013, the ministry that was responsible to prepare the law and to regulate the law, the Ministry of Customs and Trade, they had to prepare a new law, the law numbered 6502, the new law on consumer protection, to stop the wrong usage of the law and the wrong understanding of the law. Actually, the first law also included the same concepts with the second law, but everybody thought that actually with the second law, the area of consumer protection is widened. That was not the case. It was wide enough, but it was not understood enough. I have to stop here, I guess.
Yes, of course.
Sorry, at this point, may I add something?
Sure.
This is the best ever history of consumer law I have ever.
Do you hear the voice from the microphone? Okay.
This is the best ever history of consumer law I have ever heard, and thank you very much. One of our job is to storytelling. Huh? We're telling a story. Once upon a time, there was a film, War of Roses. Kathleen Turner, Danny DeVito was playing in that film, and without starting telling a story, Danny DeVito was saying, "I'm starting the clock," huh? Because they get hourly payments, the lawyers. It was a very bad example of divorce, but I do recommend you watch that film if you haven't watched so far. Here, of course, consumer law and other areas of law is very important, but in this club and in these meetings, we will also stress the importance of English and using English. That's the very perfect example of storytelling, huh? The story, history of consumer law. Thank you very much.
And I thank you very much. Actually, without knowing this history, it's not possible to understand the law on consumer protection. To understand the law, you have to know the history, and you have to know a bit the European Union law as well. And that was what was missing in the decisions of the courts and the Court of Appeals, actually. That's why they had a difficulty in understanding it. They thought that the things that are only regulated in the consumer protection law should be the consumer contracts. Otherwise, the others that are regulated, for example, in the Code of Obligations or in Commercial Code or in some other special codes, are not consumer contracts. That was a very wrong understanding. And that is because about not knowing the history, not understanding how the law and how the consumer protection law has developed, actually. So this is something quite important.
Of course. Do you have any questions, or is there anybody to add something to our
About
views?
consumer protection, about legal English, about the usage of English in law. Do you have any contributions or any experiences to share among the audience?
Just start.
Just start speaking.
Thank
What?
you.
We are going to finish in a moment. Maybe I can add something.
Please.
For the new Consumer Law Act, we see that the Turkish consumer courts are like a general courts in Turkey. When you start a new litigation in Turkey, you have to check, is it a consumer transaction or not?
The first thing you have to do
Yes,
is
you have to do
just
it first.
to check it.
Yes.
And if you want, in our next session, we can just give some hints about consumer transactions
Maybe.
before we start the distance sales. I will be
Okay.
explaining how to understand whether a transaction is a consumer transaction or not.
It's not easy to understand for lawyers, and actually it's more
the
important
judges as
for the
well.
judges as well, because they are the decision body in the Turkey, and when they don't understand who is consumer or who are not consumers, it's not easy to make a decision
So we shall
for
give
their
some
cases.
hints about that.
Of course, I think, of course, and I very liked that the sentences of the European Unions. They are simple, they are easy to remember. Maybe we can make new Turkish sentences about
Yes, we can do that.
similar to
Yes.
European Union sentences. Maybe we can use those hints. Today, our program is enough, I think, for
Yes, we
the
should
beginning.
not. We should not
There's a
bore
question.
the audience. Yes, please. Would you be kind enough to pass the microphone?
Of course.
Thank you.
Commerce has basically two sides, the consumer and the producer. Is there any regulations about protecting the producers, or they don't need to be protected?
They started to have some types of legislation in the United States. Not legislation maybe, but some types of rules in the United States, because of course it's a very important equilibrium between the consumers and producers, sellers, and other persons like that, the persons against the consumers. It should be a nice balance between them. To protect the consumers does not mean that the consumers are always right. So we have to think about both of the sides of the contract. We have to think about both of the sides of the transaction. And sometimes it goes too far in the consumer's direction, especially that was the case in the United States, and now they started to protect the producers and sellers as well. So they try to bring a balance to both of the parties. Of course, in law, the balance is very important. We have to balance the rights of both of the parties in a legal transaction. This is maybe the basis of law of contracts. The equality between the parties is very important. You're right.
Under Turkish regulation, maybe I can add one more
Please.
point. Under Turkish regulation, if you're a producer, you can make the consumer stop some of their rights. Maybe we can say this as an example under Turkish acts. Yes.
Hello, my name is Mehmet Barhan Arslanhan. First of all, thank you for your effort and time. I have a question, but it's not about the consumer's law. I want to learn about the legal English. We know that everybody says that legal English is very important, especially for the younger lawyers. And I am at the very beginning of my legal career, and I just want to know that in which areas we can use that our legal English. I don't know, or I can't imagine any job opportunities. I can't understand the occasions, but most of the people use it in very common areas. So I just want to understand this.
If I start first, then I will give the words to my colleagues actually, because they are more experienced in application. But what I know is you can use your legal English in nearly every area of law. It depends on your clients actually, because what we deal with is our clients. So if our client is a foreign client, we have to use our legal English. It can be a divorce case. It can be a custody case, it can be an alimony case, it can be a child abduction case, it can be a criminal case, but mostly where we use our legal English is commercial transactions, the contracts, most of the time. we use in drafting the contracts, we use in negotiation of the contracts, then we use in the application of the contracts. Then especially if there is a dispute resulting from a contract in which the sides, at least one of the sides, is a foreigner, then again we have to use our English. And most of the time, if the other side is a foreigner, we don't choose the country courts to work in that dispute, but mostly we go to arbitration. And in arbitration, especially in international arbitration, we need English. Definitely we need English. But it can be a tax matter as well that you have to use your English. It can be an employment contract even, especially in Turkey, we have many employees who are actually foreigners, and we have many companies who work in different countries and having many foreign employees there, even in employment relations. So it depends on your client actually. But the usage is a huge usage. And unfortunately, in today's world, in our country, we have a couple of big law firms that are known, especially in Istanbul. And most of the cases that have the usage of a foreign language are dealt with these legal firms. And the reason is, in the other cities in Turkey, most of the time we don't have many experienced legal English or other language using lawyers. So this is the situation. We have to change this situation, that's what I think. Please.
A year ago, I'm the friend of Bahar Can Demir. We graduated from Ankara University Law School in 1995. He's my schoolmate. She is Bahar Can Demir. Now she is the Bar Association President of Kocaeli. A year ago, we had a conversation more than an hour for the lawyers of Kocaeli Bar Association. I was always telling about the importance of legal English. The subject was legal English, and I was telling lots of things about legal English. At the very end of the conversation, my younger colleague asked me, even in the execution and bankruptcy law, do we need it? Yes, especially in that area, because there are huge amounts of money to be collected here in Turkey. If you can speak in English with your clients, for me it's English. Hope you can speak Spanish, Chinese, whatever. But
Sometimes Russian is very important, sometimes.
yes, but for me that's English, and all over the world it's spoken, thank God. If you can find big companies who are trying to collect their monies here in Turkey, even in execution and bankruptcy law, you need English. You need English everywhere.
Maybe I can add something. First of all, I would like to thank to Mr. Erkan, because I'm graduated from Kocaeli University. It's a very important city for our life, and my wife, she is also here. We are both graduated from Kocaeli University, and say hello to the people of the Kocaeli. I want to say that, first of all, you have to learn legal English, because if you don't know, you cannot have practices about this area. For instance, think about your clients, or think about the potential clients. If you don't know English and you don't practice legal English, the potential clients doesn't give their cases to you. So first, you have to learn, you have to practice, you have to focus on this area. And then, it's not a short time to earn money if you learn English. For example, it's easy to earn some money in consumer cases in Turkish or rental cases in Turkish. But if you learn English, you have to be patient for the right cases, for the right clients.
To be honest, I am mostly working on that commercial cases, and of course I want some clients who needs some commercial, who needs help on commercial law materials. I know English. I have taken some legal English courses in university too. Of course, I sometimes forget it, but it's hard for me to reach the clients. I know some companies, legal companies, get more the clients, mostly 70%. I don't know how to reach them. Do you have any idea? For example, when I was an intern lawyer back in İzmir Bar, I went to a bureau, law office. They told me that you are going to translate contracts. And I was so happy that I will translate them, but it was their personal contracts. They were also trading, so I don't know where to begin. I don't know how to begin translating or writing contracts. I don't know how to reach the clients. And any suggestions?
I do not have a direct suggestions. It's not easy to say how to reach the clients as a lawyer, because it's about your type of lawyering, and it's about your professional areas. For example, if you work succession law, maybe it's the you cannot use English in succession law in Turkey, I think.
Even in succession law,
Yes,
you can use English,
but
but it's limited, of course.
It's not like consumer law or not like
Mostly you
commercial
can use
transactions.
it in commercial transactions,
so
contracts.
you have to focus on contracts, I think. If you study, if you learn different types of contracts and legal terminologies, one day
Would help.
the clients are going to reach you. It's my opinion, because there's not a direct way to reach the clients.
Thank you.
Told us our first priority should be to know our law system, and upon that we have to be speaking this language. It's a little bit luck. I would like to add that, for example, at the very beginning of my career, I worked for a French company in a bank. In the bank, I was reading syndication contracts, agreements, something like that. It's a little bit luck, but if you would like to read English contracts, mostly all of the time, please try to find a foreign company to work. Otherwise, it's hard to improve your English.
What you can do is you can be a bit helping yourself in a way, and this is how you do is that you can have some CVs prepared that shows that you're able to use your legal English, you have taken some courses and so on and so forth, and you can send your CVs some companies who have some international relations. And by that way, you can start doing certain things like that. You know that all joint stock companies should have an in-house lawyer. They have to appoint a lawyer. And what you can do is you can offer them to be their lawyer, and you can offer them if they have, for example, we have many construction companies like that that are having some international construction contracts and things like that. You can offer your help to them by sending some CVs. This can be a way to just have some relations with them. Some of them have their in-house lawyers, and most of the time these in-house lawyers' English is not enough to deal with these kind of contracts. And what you can offer is you can offer help to them, and it can be a starting point.
But first, I guess I need to learn the contract.
Sure. Sure. You, first of all, you have to know your law. This is the first step, actually. You have to know your law, you have to know legal English, you have to know the concepts, and you have to have an idea, especially about if they have some relations about common law systems as well. You have to be aware that the concepts can differ, not only among common law countries, but also among continental law countries as well. So you have to be able to understand that. This is a crucial point. Okay? That's all.
Hasan Hüseyin Bey, maybe it's very helpful for our first meeting. Most of the time our clients find so many contracts from internet and bring them to us, and they say that why haven't you added these articles to your contract? I say that is this applicable to your situation? No. This is no. This is no. That's why I'm trying to make a contract tailor-made for you. I'm not copying something. Our professor told us that we should know this law. This law says this, and according to your situation, I have prepared a contract, and this is your situation. For example, there is no lawyer around, and they say that let's write about lawyering costs, something like that. And another point is to know the concepts of common law, legal systems. For example, especially when it comes to damages articles, what I like most is punitive damages. When you see this word, please become alert. Okay, punitive means just to give extra compensation for the other side. For example, the other side lost $100,000, but they may get $1 million. Punitive means to give special. That's not imprisonment, but for a company, it's more serious than that. You're losing so many. So much money.
Yes. The thing is that, especially regarding the damage types and the types of damages, damage and damages are two different words. We have to understand that. Unfortunately, the common law countries, since they don't have a code like the code of obligations we have, they have to regulate everything in their contract. And the type of damages they can ask is more than the type of damages we can ask. So we have to be very careful about that, because in our country and in all the continental law countries, we have a code that regulates them. And some provisions of this code are compulsory in that area. So we have to be very careful, especially in using the terminology. Even we have to be very careful. So I think we have to stop here. We should not bore.
Okay, we can stop, and I can add some point. Sometimes you create the client and job. You make a direction to your client. For example, you can export your products to another country, and then you have to prepare a contract in English. That is why you direct it to your client. Sometimes you create the job, you create the case. Thank you very much for your contribution.
Thank you very much.
And now maybe we can stop talking English for the closing remarks.
Evet, çok teşekkürler.
Hocam ben teşekkür ederim.
Bence
Çok
keyifli oldu.
güzel, keyifli bir sohbet
Evet.
oldu. Tüketici hukukunun tarihçesinden, dünden bugüne Amerika'daki, Avrupa'daki uygulamalarından ve bugüne nasıl geldiğimizden bahsettik.
Ve özellikle de bizim kanunumuzun nasıl çıktığından
Yorumlandığından,
bahsettik.
çıktığından. Bence o bir şansmış sizin için, hala o görüşteyim.
Evet, bilmiyorum.
Çok güzel bir sohbet oldu ve beklediğimden daha çok katılımcı geldi açıkçası. Buradan da takip etmeye çalıştım bir taraftan. 30'un altına pek düşmedi izleyici
Süper.
sayısı. Baron